welcome all for the second session. So the two previous speakers spoke about the personal quality and therefore the quality of their institutions, which I didn't mention. The National University of Singapore for Professor Jamal, and University Luis Locali Rome for Professor Alicino. And now I give the floor to Professor Amirante, who is based at the, we say, Second University of Naples.
Not any longer, because now it has got a new name, Università della Campania.
Okay, so it's not it's not second to anybody any longer, which never was, by the way.
I'm also from Luogo University in Bari.
In Bari, yes. So Professor Alicino has a double affiliation. So you have the floor for your discussion and remarks on the topic.
Sure. Or maybe we can change.
No, it's stuck. Okay.
Okay. So thank you very much. And first of all, I would like to thank Roberto Toniatti for inviting me to this very interesting workshop. Well, I was quite reluctant because looking at the title, I say, here I'm like a fish swimming outside of my pond, because I'm not an expert of religious law or of family law, but Roberto asked me to come and also gave me the possibility to open up a little bit my discussion also to more general themes concerning comparative law between East and West, North and South, and so on. So I think this workshop is very interesting because the topic open up to a very interesting reflection. We are trying to build up. I have heard about the grammar for a comparative law, or rephrasing the terms for understanding certain aspects of comparative law. I think we are trying to build up new foundations for comparative law by building a common ground between East and West, North and South. So that's very important. And I think the first thing that we have to try to overcome is the traditional distinction between colonial and post-colonial countries. That's very important because the post-colonial countries, they have, in most of cases, they have built up very original and independent constitution, and so new legal system. It's not always the case, of course, but in many cases it's like that. So it's quite important to overcome this traditional distinction. In fact, the colonial, post-colonial perspective implied that post-colonial legal system and constitution were considered at the best as a mere reflections of the Western colonial legal theory. That is to say, mere reflection of the Western template of law, with its duopoly based on the distinction between common law, civil law. That was the template. On the contrary, like, for example, Roberto Toniatti rightly pointed out, there were two cultural paradigms: the rationality of Western law, that was positive law or judge law, against the holistic foundation of other laws that was seen as something traditional and something to completely destroy or abolish. For example, in the traditional handbooks or of comparative law. We can refer to René David, or we can refer to Zweigert and Coates. The law from the East or from the South was considered just as other conception of the relation between society and law that were not relevant for the construction of global paradigms of comparative law. And as a consequence, the performance of these new systems, of the new constitutions, was measured through the quantity of Western rationality that was introduced in it, and to the subsequent modernity that was attained by accepting the Western monist legal template. So what we have listened today is the demonstration that this perspective was completely outside of the reality of those systems, and also was not getting to the point of what Asian law is, but is not getting the point of the potential that Asian law has got for legal theory, generally speaking. So just take the example of India, how the Indian system was considered in the 50s. It was considered like an unmanageable mix of different influences and incomplete institutions. They were speaking about the elephantine constitution, 395 articles and so on. They were speaking about quasi-federalism and confusion between a Westminster system and other institutional solutions that were considered inside the text of the Indian constitution. Generally speaking, the destiny of India was an imminent Balkanization. That was the judgment in the 50s. And of course, all that proved completely wrong. And probably the only Western voice considering the innovative potential of the Indian constitution was Granville Austin, that is never quoted in comparative constitutional law books. So that's quite important. Maybe only in India and around India they know who is Granville Austin, but outside is not very well quoted. So I think this is a very telling example of the problems that the traditional approach to comparative law is giving us. Today, on the contrary, there is a very important reconsideration of this template, reconsideration that is based on the recognition of legal pluralism as the future of the majority of legal system in the garb of globalization. So we are trying to open up our minds to a different system in recent time. But again, quoting Roberto Toniatti, we must stress that looking at a world map, legal pluralism of one sort or another, including mixed jurisdictions, happens to be the general rule rather than the exception in a large majority of countries. In a recent workshop studying methodology of comparative law, I dared to say, up to now we have studied the law of the 19% of the states that are in the UN Assembly. We did not study the 81%, and I was criticizing that, but I was not very well received by all the other colleagues of this comparative law conference. But that's a fact, I think. That's a fact. And this new shift in comparative theory involves a reevaluation of the theoretical potential of taking Eastern legal orders seriously. Just to use a standard of our time, and such developments were somehow anticipating by some authors like, for example, Werner Mensky. I just remember the very comprehensive book, Comparative Law in a Global World, of 2006, that with reason is considered the blue Bible of global comparative law. And he very recently, in an article of 2016, reminds us that Indic cultures are ancient and richly diverse, and that the Enlightenment was a culture-specific advance not shared in the same way by the whole world. So as a consequence, colonial civilizing efforts are actually being reversed today, and he was thinking not only about Asia but about Latin America, for example, with all the new constitutions that have arisen after 2000. Namely, we can think of Bolivia, Ecuador, and other new constitutions. In this intriguing essay by Mensky titled Still Asking for the Moon, that Mensky considered very productive that outside of the common law circuits or the Commonwealth family, many legal scholars from civil law countries, especially in Italy and Germany, are seriously considering Asian law and Asian perspective. So I have to thank Roberto for having taken an Asian law course in Trento University. It's very important for Mensky because non-Anglo-centric writings may tell us more about recent Indian development that work by those who are or feel somewhat overpowered by the reverberation of lingering pride about the achievements of colonials. So that's a very interesting perspective, also because it's, I may say, because I come from the south of Europe, a south-south perspective, and not a north-south perspective. So that's also very important. But for Trento, it's difficult because it's in Middle Europe, so it's more difficult. But for Naples, you know, a south-south perspective, it's just what.
North without the south.
Yeah, of course. Nevertheless, the interest for Asian and South Asian laws is not very widespread in Italy. I want just to finish this part of my discussion with a brief anecdote. Recently, I've published a number on multiculturalism and language in different constitutional systems, studying what is the relevance of multilingualism in structuring the shape of the modern state and then of the contemporary state seen as a multicultural experience. And then we had some page limits, so we had to choose. There were 15 articles regarding different experience all over the world. We had to publish only a part of that, and then the community, when we discussed which part to exclude, which states to exclude, they wanted to exclude, of course, Asian states. So I managed to publish India, but I couldn't manage to publish, for example, Nepal. That for me was the most interesting one because a recent constitution with many languages and tried a new path for the management of linguistic diversity in a federal state, even if we have to see if it is going to be implemented, because that's another problem. But as a constitutional text, as constitutional theory, it's very, very interesting. But it was excluded because it was Nepal. If it was, would have been Switzerland or whatever, would have been included. So that's another reflex, but that's mostly an Italian problem. Especially in the field of comparative law, the potential contribution of Asian constitution and Asian constitutional systems is very important. And again, I can just consider India, that is the constitutional system that I studied the most, maybe, and not by chance, because I think it's the most promising in the perspective of a true dialogue between East and West. Of course, there's one advantage is the language. Is in English, so it's very easy for us to understand and study. We don't have to recur to translations from Asian languages. Another important reason is because it corroborates a new perspective for the trajectory of the state, the development of the state. That is that of the multicultural state that I consider as an evolving phase of the welfare state and of the democratic state. And in fact, in a recent book, I defined the Indian Union as a prototype for a multicultural state. And we've heard the reasons why we cannot consider India as a model, but just as a prototype, an experience where we can find interesting hints, but we cannot copy it, and we cannot even dare to suggest copying it. In fact, the Indian Constitution represents a very successful combination of a wise use of models and institutions of the Western traditions. Ambedkar in the Constituent Assembly said, we have just taken up some Western models. The only thing we have done, we have avoided all the blunders and all the errors that the Western constitutional law did. So it was a very interesting attitude. On the other hand, there is an original interpretation of the state itself, that is a modern state, but a state that also is based on traditional basis. So it's completely different from our conception of the Constitution stemming from the liberal age, where the French Revolution made tabula rasa of the past and constructing a completely new order. Of course, with all the enthusiasm of the possibility of building such new norms, but also creating a very important historical rupture with the past. And so we cannot promote this model for the entire globe, because it is a part of our history. On the contrary, the Indian Constitution was structured on the basis of a specific idea of a combination between social structure, the political community, and the legal structure. And that brings us to a specific aspect, that is Indian modernity, that I also dared to define like a postmodern conception of the Constitution. Of course, in our mindset, it's postmodern. For them, it's just contemporary. They don't need this continuous reference to the modern world and the postmodern world that we need in Europe and in the West generally. So I think Indian Constitution has some postmodern resonances that we consider as contradiction. For example, they have got a Westminster system of government, but it's a pluralist Westminster with 35 to 40 parties in the parliament. The classical Westminster system has got 2 or 3 parties within the parliament. They have a federal union with centripetal tendencies. That is a contradiction in itself. And one field that is very relevant, I think, has nothing to do with what we have discussed today, for example, is environmental law. That is a very typical postmodern discipline. And India, for example, was the world leader in the creation of environmental tribunal, specific environmental jurisdiction that are characterized by benches composed half by judges and half by technical experts. that are not technical expertise from outside the bench, but that decide the case within the bench. And the benches always have to be 50-50 between the traditional legal and we might say that the secular or the scientific aspect. That's a new form of jurisdiction. In Italy, I don't think we will accept that a judge could decide a case without having a law degree. That is quite accepted in India, and this tribunal is getting more and more importance. At their conference last year, I could have tea with Narendra Modi. This year, also with the President of the Union, and so on. So it's getting a central stage in the Indian debate about environmental problems. I don't think are not important today. So this was just an example, but before finishing my discussion, of course, I need to mention the very, very interesting presentation that we had today that are teaching me a lot about the links between traditional system and modernization and contemporary law. And for example, in the presentation by Arif, there was a lot of insistence on this symbolic importance. I think the debate over the introduction of the common civil code in India plays a lot around the symbolic importance, and that's why we have some difficulty in understanding how now leftist liberals in India oppose a civil code, while yesterday they were promoting a civil uniform code. In fact, it is could be, and that maybe I can. Because I wasn't here yesterday, I would like to put this question to Arun Tirunvengan. Can be just an electoral theme, an electoral topic that is used by the different majorities in order to gain support. For example, in this case, for the Indian press highlighted that was used for the Uttar Pradesh elections. So how this is linked to the legal technicalities and to the political use of the law commission that has been made recently by the Modi majority. So that's very important, because we are always discussing on a double scenario, the symbolic one and the real one. The real one is saying us that there is no need, there is no urge to introduce a common code, and the experience of other states, like in the Singapore situation, explain us that the tendency, the trend is more toward an application and a confirmation of various personal statuses in many constituencies, as Singapore and other countries that were mentioned in your intervention. So I think it's very important to study these systems. And what comes out for me, and it's very important, and I wanted to ask you, because you raised the question on what are the limits of pluralism. So I would like to but you couldn't answer to this question because of time, shortage of time. So I would like to ask you how you consider constitutional law can frame the limits to pluralism, and also this brings us to the discussion about the tolerability of certain religious traditions and rights, and the tolerability of customary rights, and so on. So two aspects. One, the tolerability is more kind of moral, political. The limits of pluralism is more constitutional, legal, and so on. But that was really very, very relevant for me. Also to know data, and that must be widespread. We have to know the data about the percentage of different religion and how they are intermingled with the ethnic origins of the people living in different constituencies. That's very important also for us, because as in Europe we are facing some immigration waves. We have to know that Muslim from Pakistan or from India is not the same as Muslim from North Africa or from the Middle East, and so they have different visions of their religion, of their religions, of the role of the religions in society and law. So that's very important, I think, very relevant for us. Another very important aspect that came out from your intervention was the tension between the right to religion, the freedom of religion as an individual right, and that was also a problem that came out of the relation by Francesco Alici, and the religion as a group right. I think there is no theoretical inconsistent between those two situations, and maybe the Indian situation is very useful to explain that. Right use in the right time and by the right institution of legal pluralism can manage this aspect. Because in the Indian constitution you have a very large freedom of religion, and also religious communities have a lot of powers to establish themselves, to create cultural relations and cultural institutions. So that's quite interesting, and so on. That could be also a very interesting question for Arif, if you can compare the Singapore situation and the Indian situation. But maybe by asking that, I also know that the numbers are important. So Singapore is very small and India is very huge. So the comparison risks to be highly theoretical and not really important on a factual plan. So I think this is very, very important. So maybe the second part of your lecture could have been developed more when you speak about the potentials and the pitfalls of pluralism. And I was very interested by your distinction between plurality and pluralism. I think this is very important because in Europe, for example, when we highlight plurality, we are automatically we are considered on a certain political agenda. We are considered to be the radical, pro-immigrants, and so on. But we are just highlighting a situation of plurality and an increasing plurality that we are having in the European countries. Pluralism, legal pluralism, is something different. It's a choice made by mostly by the constitutional system and then by the other legal actors. And so that's very important, and I agree completely on the fact that we have to refine the grammar of comparison. And similar hints come from also from the presentation of Francesco Alicino. That's very, very interesting. And from his presentation, much more than from Arif's presentation, comes out the importance of the colonial legacy. In fact, I think, and I would like you, if you can, you highlight more the difference between Pakistan and Bangladesh, but they have a common problem that the colonial legacy that is, in my sense, a sort of crystallization of Islam, was used by the political elite in both countries for their political agenda. So they exploited the blunders of the colonial past just to reinforce their power. And this clings with the reality of the society that, on the contrary, both in Pakistan and most, I think, in Bangladesh, is very diverse and very willing to cooperate each other and so on. So that's an aspect that I would like you to highlight. And of course, from a constitutional point of view, the Bangladeshi situation is more kind of intriguing, because how to compromise a secular constitution with Islam as a state religion. That's the main constitutional point, I think. And again, I think we have, when we consider, and I will finish by this remark, when we consider secularism, we must know and understand that secularism in Asia is something very different from secularism in Europe. In Asia, they don't have introduced the model of complete separation from between state and religion, the wall built up by the Americans or whatever. I was very influenced, I have to admit it, by the book by Jacobson, The Will of Law, that is describing the American system as a neutral one, the Israel system as a militant religious model, and on the contrary, the Indian system as a ameliorative secularism. That is to say, a secularism that is not based on a separation, on a complete separation between the state and religions, but as an active state that is promoting and trying to promote at the same level the religious belief, so the religious communities, without discrimination between them. So that's an important, I think, an important framework to understand the differences and not to ask to Asian secularism something that Asian secularism cannot give, because they have a completely different vision of secularism. So I think this presentation were highly interesting, and they raise many questions, but they also indicate a path for refining, and I insist on that, the grammar of comparative law in a global world that is not any longer discriminating between Western law and the rest. So it's not any longer the West and the rest, but us.
Thank you. Thank you very much. So I think we can move straight to discussion and involving the room. Instead of giving you already the opportunity to reply, you will have plenty of time afterwards. So I invite everybody who's in the room to share remarks or ask questions to our speakers. Of course, the speakers from yesterday, welcome to again take the floor. Roberto, please.
Thank you. Let me start. As I found also
Yeah, maybe need a mic. Yeah.
I found
Thank you. I found the presentations this morning as interesting as the ones that we had yesterday, so thank you very much, speakers and discussants. I have one very short question for Professor Jamal. When you quoted, I think you quoted Leo when she said that Singapore does not favor irreligion over religion. My question is, how about a favor of religion over irreligion? So I wonder if it goes in both ways. Perhaps it doesn't, and perhaps that was not part of your quotation. Just I wanted to make sure, because it might still help us to understand a little bit the relationship between religious pluralism and legal pluralism, because this is always, I think, very much at the heart of the matter. How society is plural, how society is religiously plural, and therefore is also plural from the point of view of the law, of the legal system. Then also, let me also from the culinary point of view, let me say that perhaps the Irish stew is an equivalent to the rojak, at least from the point of view of the language. Although I don't think the Irish stew is as rich and plural as the rojak. But anyway, let's come to more serious questions. And the point is, the final point that I would like to raise is the consistency between legal pluralism and the democratic paradigm. Because this is really, I think, quite crucial. There's one statement that Nico just made, and on which I don't think I agree. You said that legal pluralism has been the choice of Asian constitutional makers. Now, I think that Asian constitutional makers did not have a choice. They could not neglect religious pluralism and therefore legal pluralism. Where did they do have a choice? I think in socialist systems. If you look at the Constitution of Vietnam, you don't find any reference whatsoever to legal pluralism. You only have the usual blah blah about religious freedom, but nothing about religious pluralism. And of course the same in China. So in all other countries, constitutions cannot but reflect society. And that's why, Nico, I think they didn't have a choice. They didn't have a choice because, of course, a constitution, to some extent, is supposed to set goals to be achieved, the policy guidelines and whatever, but also, to a large extent, it has to mirror society. It has to accommodate plurality which exists in society and which you cannot neglect. Now, why do I think that in Europe we are so hesitant, and sometimes we have so many perplexities about legal pluralism as it exists in Asia in particular? I would say because the experience of Asian legal pluralism is very aggressive on our own pride about being plural. We always consider Europe and liberal constitutionalism as the best historical protection for pluralism. And we find out that this is not the case. And this is why we are so reluctant to go deeper into it. Now, not that Europe is not really, let's say, keen in cherishing its own pluralism, but yet we cannot avoid the consequences of modernization, which to a large extent entails secularization, so that the uniformity connected to modernization is, I would say, secular uniformity. And secular uniformity is quite inconsistent with legal pluralism. Of course, we have two basic concepts that protect secular uniformity. One is the Constitution as the supreme law of the land. I wonder, for instance, in Pakistan and Bangladesh, but that's also in Egypt, for instance, to what extent does the constitutional proclamation of Sharia as the supreme law is contradictory? Because is it declaratory, it is a declaratory statement, or is it constitutive? In other words, is Sharia applicable, or is Sharia the supreme law of the land, irrespective of any constitutional acknowledgement, or is it not? And then, of course, the second concept is citizenship, which is the first emergence of the concept of uniform formal equality. But then, of course, even in Europe, we have had pluralism within the legal system. Let us think of also on base of religion or ideology. Let us think of all the acknowledgement of areas of conscientious objection, for instance, or to have special legislation for groups. We mentioned the turban and the kirpan for the Sikh communities. We have affirmative action, and we have the mirroring of the principle of substantive equality. What Europe is very reluctant to accept is the idea of religion as an alternative legal system encompassing all aspects of life, family, gender, sex, whatever. And I think that one of the reasons is exactly the lack or the inconsistency with the democratic paradigm. In other words, the alternative to the legal system, to the uniformity of the legal system, are accepted and acceptable as long as they are the outcome of a democratic process. In my understanding, in most Asian countries, the acknowledgement of legal pluralism is, as I said, of course it is the object of constitutional decision making, but without any alternative, without any real choice. And I would say this is a basic difference that we have to take into consideration. And of course, I would like to have your opinion on this, because what is unlimited pluralism in Asia is not what would be labeled as unlimited pluralism in Europe.
Okay, thank you. I will immediately give the floor to Professor Jamal for a quick, to-the-point reply on Theo's quote.
Sure.
Without taking
The rest
all
of
the
it.
other,
Just
the rest
reply
of
to
it,
that.
and then,
Thank
yeah.
Well, the answer is to that question, perhaps. But I say this because both because of the, as it were, perspective of the particular author, Theo Lian, and her own commitments, but also, I think, because in a society like Singapore, where you have, as the figures showed, a fairly high degree of religious affiliation, the challenge might be to show that you are not favoring irreligion. Right? But, and this is why the answer was perhaps, the most recent demographic information suggests that actually you have to take that figure of religious affiliation, and when you break it down by age cohort, you see that there is a declining level of religious affiliation amongst the younger people. So the demographic change is happening. Right? So that figure of whatever number it is, if for instance, if you say that within Singapore the total percentage of the population which don't have religious affiliation is roughly 17, if my memory serves, it is about 25 or 24 amongst those, say, under 30. I mean, I have to get the exact figures, but this is what's up. And therefore, that characterization, I think, is responsive to the situation as it is, but perhaps will not be as responsive to the situation as it will develop.
Thank you. Any other? Domenico Francavilla?
Thanks. I have a question for Francesco, taking the political dimension underlying the issue of the Uniform Civil Code. I was wondering if the Pakistani Hindu Marriage Act 2017, this is very recent, is part of a kind of communication between Pakistan and India and global Muslims or South Asian Muslims. So it's reassuring, it's a message we are protecting Hindu minorities. We expect the same about Muslim minorities in India. So this kind of communication. While in more general terms, I was thinking about one of the main issues that Arif raised, that the relationship with personal autonomy. So this missing religious law, community laws as potentially violative of individual rights, that we, in our mindset, we expect that the state should protect the individual against the community. This is, I would say, a legal postulate in the Chiba acception of our Western conception of law. But I was also thinking that in Europe we also have a very strong idea of how we will say intermediate bodies, social bodies. So legal pluralism studies in Europe, in Italy, Santi Romano, very much stress these intermediate bodies between the individual and the state. And we can also think that historically or even hypothetically, in some cases, it's the community that protects the individual against the state, because we assume that the state is the nice guy, but in some experience, it's the state that may be oppressive. Or we can imagine right now a community, let's say a Hindu community, where all the gender equality, all the rights are preserved and protected, while an hypothetical state, on the contrary, can have anti-sodomy law. I'm not making the reference of India, it's an hypothetical. So community laws, at least in principle, maybe in some cases more progressive in contents, in our view, of the state. So this is interesting in my view, because a part of the problem is the relationship, the formal relationship, the grammar between these agents, the state, the community, the individual. But at the end of the day, and in this way I recall the start of the session with the words of Marco, the issue is the protection of rights, of needs of the individual. So this shift in terms of contents is it may be interesting, but of course the problem remains who decide what is right for whom. So this is at the end the problem: who decides what for whom. So I just would ask you some more reflection on this, and just if I have time, just one other remark. Francesco made some reference to this typical common lawyer attitude in the British Raj to intervene very specifically to correct. This is common law, classical statutory law technique, to correct, to restrain. So we have the Child Marriage Restraint Act and other legislation in the colonial period to correct the most problematic aspects of personal laws. And in a sense, when yesterday I was talking about the idea of the code and I made a reference to the European Civil Code, the debate on the European Civil Code, I remind that Pierre Legrand, who is very critical about the idea of the European Civil Code, say that to think nowadays about codes in general is backwards. Probably the code is the legal technique of the past. Nowadays, the very same idea of the code could be seen as an ideology of the past. Probably we need other instruments to navigate this complexity.
Thank you. Professor Thiruvengadam.
I want to begin by saying that this was a very stimulating discussion, and I want to thank Arif, Francesco, and Domenico for that. Just thinking about, so first let me ask a question. So this is emphasizing a point that you've already made. As I listen, and I should probably start with a confession. Yesterday, Domenico made a confession that when he was looking at these issues, initially he came from this idea of being for legal pluralism, but as he has gone along, he's begun to see perhaps some value for a uniform civil code. And perhaps that's because of where Domenico is coming from. And yesterday we had a discussion about crossing boundaries, how we are a very mixed group and we come from different perspectives. So in similar light, I was struck by your statement because my own view has been the reverse. I think being a constitutional student of constitutional law and believing that there is some purpose in harmonization, I started with that, but then particularly when it comes to personal law or in other cases, constitutional federalism, which Domenico also mentioned, you realize that there is value in having leeway in the joints, so to speak. So I come from that perspective. As I listen to both the presentations, I guess I'm thinking of it from the perspective of sort of a broader perspective, not just law and religion, but thinking of these. And I was struck by the effect of things which I think are implicit in that, and I guess I want both speakers to just articulate that a little bit. So going back to that first point about colonialism, it's striking that when you look at Singapore set against Pakistan and Bangladesh, what is interesting is that in Singapore there is personal law, but only for one community, and there isn't for the others. And that's interesting because during the colonial period there were some kind of personal law regimes for all ethnic communities, but that was given up. And that's interesting. And I think that has something to do with the model of state development that was taken. Singapore, as we all know, very much the developmental state idea that informs ideas of constitutionalism, ideas of economic policy, and the idea that Arif sort of emphasized, this idea that you have to manage religious relations and you have to contain it so that the broader national project doesn't get affected. And you always emphasize that broader story of national unity, national progress. And that, so in both Pakistan and Bangladesh, I guess it plays out in a different way. I mean, we know that the state of Pakistan is created on the basis of religion, but breaks apart on the basis of language. And again, it's a sort of reminder, and to me in South Asia it's very clear. When I come to Europe, there is a tendency to say, oh, somebody is Muslim, and that somehow is a complete identity, which controls every other aspect. But in South Asia, it's evident in India too, where Muslims and Hindus, depending on which part of the country they come from, which language they speak, which region they belong to, are different. And I think, I mean, thinking of our conversation last evening over dinner, it is true, of course, of Italy as well. I mean, people are Italian, but they are much more strongly identified with a particular region and that regional identity. Though, I guess in your case, you still have a common language to do that. In India, it's complicated because of all these other factors. But I think Pakistan and Bangladesh's story reminds us that sometimes there could be other identity markers which are much stronger. So this idea, Jinnah's two-nation theory, famously broke down when the West Pakistanis just tried to hammer Islam and neglected the fact that the Bengalis had a different cultural identity and attachment to language, which was just not respected by the West Pakistanis. And the imposition of Urdu arguably caused also the breakdown of the state of Pakistan. So in that sense, I'm struck by that story, but also the fact that looking at it from the point of view of constitutionalism, both Pakistan and Bangladesh have struggled to maintain a sort of constitutional regime, and that has something to do. So I was looking at your slides and the dates for many of these laws in the post-colonial period. There must be an interesting connection between martial law in both these countries and when important pivotal legislation has been passed. So I think Matthew Nelson has argued, at least in the case of Pakistan, that there is an interesting dynamic of when amendments to personal laws are pushed through during military or democratic regimes. So from my, I know very little about personal law in both the countries, but I'm struck by that connection. How is that happening? And the connection to India is very clear. Nehru wanted to reform Hindu law. He was able to do it even with all the authority as a founding father that he had. He couldn't do it in a democratic setup and had to give in to a much more negotiated sort of result. And since Nehru, reforming personal law has become almost impossible. There are very few instances of successfully doing that. The 2005 Hindu Succession Act, or if you take the Christian community in 2001, when they finally were able to make divorce laws in India not gender neutral, but at least more gender equal than before, it took about a decade to sort of do it. And in a democracy, to try and do this, especially when it comes to minorities, becomes much harder. So the fact that in both Singapore and in Pakistan and Bangladesh, you have models of constitutionalism which for the most part can, to use Mark Tushnet's term, have authoritarian constitutional models is very interesting. And this to me relates back to the Indian context. So I mean, the one part where I disagree with Domenico about India being a prototype for a multicultural nation, clearly you're talking about pre-2014. So yesterday's talk, my focus was on the last 3 years, and it is not coincidental that Narendra Modi, about whom we don't know very much of his attitudes and who's inspired him, but he's on the record to say that for him Lee Kuan Yew is one of the greatest leaders of the world, not just of Asia. So in a way, Arif's presentation is very interesting because he is telling us how the Modi government looks at it. And that is why the Uniform Civil Code is suddenly back on the agenda. And there is this idea that we need to manage this issue. And we will do it through law, we will do it through a process of state-led action. Right? And in that sense, it's interesting that for the RSS, which is the body, the Rashtriya Swayamsevak Sangh, which informs the BJP, if you look at their writings, the future of India for them is the past of Europe. Right? So they are very much wedded to this idea that for India to really develop and become a superpower, you have to mimic Europe and have one identity, a Hindu identity. Everybody must recognize that. And a clear, they're also imposing Hindi much more than they did earlier. There's a way in which Hindi is being pushed through now. So a lot of the things that we took for granted pre-2014, that the federal model will be much more permissive of state-led sort of models, all that is changing. We are going back to a centralization, and in the Hindu imagination, a secularization, because it's like the state of Israel. I mean, it's a secular country, but there is one dominant religion. So ironically, in that sense, we are mimicking Pakistan and Bangladesh. And the scary scenario for most Indians is that the future of South Asia will be like old Europe, not the new Europe that you want to talk now about, which is recognizing plurality and engaging in legal pluralism. Sorry, so those are questions.
No, very, very precious. Chiara Lapi?
Thanks to the two presenters. And I have a question for Professor Jamal. And the question is about the maintenance of religious harmony act. I was wondering if this word religious harmony, and particularly the word harmony, is a religious word, is a word which comes from a religious background or a philosophical background, and in which way the state realize this religious harmony. I mean, how in the reality, in the daily life, this presidential court for religious harmony act and decide in order to maintain this and to reach this aim. Thank you so much.
Thank you. So we have 15 minutes left, and what I suggest is that we go in the reverse order with the three panelists. So Amirante, Alicino, and Jamal. Be sure you let's say 5 minutes each, okay? Let's say 5 minutes each, no more than that. And then Professor Toniati will have the floor for the final remarks.
Okay. No, even less than 5 minutes. I just want to replay back both to Roberto and Arun. On the question if India choose to be pluralist or not, I think the comparison with what happened in Pakistan and lately in Bangladesh gives us the answer. I think it was a political choice to not to build up a state that was based on some ideological and very strong commitment to a specific idea like in Pakistan and so on. Of course, it was not, it was in the 50s, so the word multiculturalism didn't even exist in that period. They were speaking about composite culture and so on. But and the choice, I think, it was also a choice determined by the opposition with Pakistan. So that they really wanted to build up a different state from what was going on in Pakistan. So I think it was really a choice, and the Constituent Assembly did it very, very deliberately, and they decided also that that was not going to be a very ideological choice, in the sense that they wanted to realize this project of composite society step by step. They didn't want to impose it with the constitution itself. That was why, for example, they realized a very limited compromise on the language question that was solved piecemeal through the times, and that involved also the reorganization of the federal structure from the provinces to 14 states to 29 states up to today. That was, I think, a deliberate choice to realize a pluralist order as a process and not as a specific ideological input given in a determinate time. So on that, I don't completely agree with your idea. And of course, what happened in Pakistan has demonstrated that that was the right choice for such a diverse social and political situation like in Southeast Asia in this period and even now. The second aspect we can I was brought to think is that the problem of contradiction between liberty of religion and a certain arrangement and central arrangement based on the groups, the religious groups. So, do the individual has the possibility to behave differently from his group? It's a typical problem of a multicultural society. We have, I think, to get accustomed that in present society we have multiple loyalties. So we have competing also loyalties within the society and within the individual itself. So that's, I think, the most difficult, because the Western legal thought, I think, basically is an essentialist legal thought. Monist, there is one truth, and so it doesn't accept multiple loyalties, it doesn't accept competing loyalties. That's a very important theoretical problem. So how do we manage? And the Indian system, it's an interesting answer. Of course, there were some, I agree with Roberto, that there were some basic facts that pushed toward this situation, but these basic facts were not considered in Pakistan and were not considered in Bangladesh, for example. Another different situation is in Singapore, and of course the perspective highlighted also by Arun of the developmental state tells us why it is different both from India and from Pakistan. But I think essentially this is the problem we are facing in terms of theory and in terms also of practice, the problem of multiple loyalties and of competing loyalties. There is cutting through groups, individuals, states, and the entire constitutional setup. And also with what can India tell us about the political developments? I think that me and Arun, we have very different perspective, and that's what is interesting of comparative law, because we look the same object from different angles. And we, for example, looking at what is happening now in India, I try to have a very historical perspective. So I think now the situation with Modi is comparable from a certain point of view to the situation, the favorable situation that Indira Gandhi had in the 70s. And when he tries to force the favorable situation to such an extent to change completely the Indian state, she failed. And that was an electoral defeat that moved her to go back to the traditional, to the basics of the Indian state. So I think that there is a limit, a constitutional limit for the changes that this present government is trying to make to Indian civilization, I may say, generally speaking. So I'm quite confident that in a long run we will see that the Indian democracy will react towards a radical change of its legal, constitutional, and composite essence. So that's why I see it differently from, of course, they are involved day by day in this struggle against this big, huge power that now seems capable to do anything they want. But I think in the long run, there will be a different evolution.
Thank you. Thank you. I will be very short. Domenico, the question was about the Indian Marriage Act, which was approved, I said a few weeks ago, but actually it was approved, I think, 10 days ago. So I did, yeah. And I didn't have a time to look in depth this act, but my impression is that this is a clear message. I would say a paternal message from the majority to minority that we are here to protect your rights. And I don't know, we will see if this message will be used as a symbolic message with a real effect, or just an act to accommodate some political conflicts. About what said Professor Amiranti, the India secularism is very different from the Europe secularism. I do think that we have to avoid the centralization of Western secularism even within the Europe, because you know, in the European Union there is a diversity, there is a strong diversity in the way secularism is experienced. If you look, for example, the French laïcité de combat, it's very different from the principio supremo di laicità, supreme principle of secularism in Italy, as the Constitutional Court called it. So we have to focus on this. I think there is a plural vision of constitutional secularism, the way this principle is really experienced in the Western tradition. Aaron, it was very interesting when you said, since the Nehru, there was a sort of the impossibility of reforming personal law. It reminds me the history, the Italian case in personal law, because if you look in the past, during when the Democratic Party was in power, and he had been in power for 40 years from the end of the war until 1992, and we during that time we experienced a very important reform in personal law. Think about the divorce or abortion or other case. And now it's very difficult. We have a very political pluralism system in the parliament, but it's very difficult. And in this case, I would mention the recent law which was approved the last year about the same-sex couples in Italy. So it's very interesting this connection. That's all. Sorry for not answer, but I think the time is running.
Thank you. Yeah, thank you. Let me try and combine some of the questions that were posed both by Professor Amiranti and also the others, but I take some in slightly different order. So to Dr. Lapi's question with the Maintenance of Religious Harmony Act, I think that's a fairly straightforward one I can answer. Is it a religious concept or is it a philosophical concept? I think my answer would be no to those. It's a political concept. I should add that in Singapore, it's not just the emphasis on religious harmony, it's racial and religious harmony. This act, of course, addresses religious harmony, but they also worry about racial harmony. How does the state go about realizing it, which was your other question? And I'll also speak about whether or not it's really being realized. There are a series of what we lawyers might call soft and hard law norms. There are a number of acts, and when somebody is seen to be stepping outside of the boundaries, the acts can come down, whether they're criminal or others, and really put that person in place. One recent example was this young fellow named Amos Yee, a teenage blogger, said things which were supposed to have been offensive. He was, prosecuted for that. He's now gone and sought asylum abroad. So there are other ways, which are the soft law ways, bringing the leaders of the religious communities together in a rather Asian way. When you need to give somebody a message, you have a cup of tea with them, right? So there are these soft law ways. Is it realized? Is the religious harmony realized? Well, at one level, you might say it is, because people go to mosques and temples and churches all the time. There is a certain amount of accommodation. On Friday afternoons, if you don't park your car exactly as you should have, where near the mosque the police will let it go because they know it's a prayer time. Similarly, perhaps on Sunday mornings for a church. In some senses, it's very free. In other senses, these tensions don't go away, right? And particularly now, for the Muslim community, with the concern about sort of jihadism, there is a concern of whether or not actually the government is kind of stepping in too harshly to control that in the name of security. Okay. To Professor Francavella's question, and this I think is also linked to Professor Toniati's question. Professor Toniati's question was about legal pluralism and democratic choice. Professor Francavella's question, if I understood it correctly, was the question of personal laws violating personal autonomy and the question of intermediate bodies between the individual and the state. Well, in both senses, and I think Professor Francavella's question suggested it, of course, I don't want to get too much into political theory, but there are great political theory questions about, who we are and what our politics has to recognize. One may be a Catholic, but also an Italian, a European, a lawyer, a father, a violin lover, etc., etc. How much, and Professor Thirengna mentioned this, right? Sometimes, for example, with any religious group, we say, well, so-and-so is a Muslim, and that is constitutive of the person's identity. These things aren't always the case. And so this is why there is this tension, I think, if the intermediate body is taken as reflecting or expressing everything about that individual. Because you are, say, a Hindu, this particular body will speak for you, and that is everything. That's all we need to know about your identity. That becomes a problem. At the same time, that is part of who you are. And so the challenge, and I saw this in the Canadian debate about religious arbitration. In the Canadian debate, the Marion Boyd report, she, for example, had a number of different Muslim communities come and be represented in the report. And you can see this list of them. And her recommendation, if I understand it correctly, was not that the government of Canada do, which I think happens in certain parts of continental Europe, say, right, we'll now have the Muslim body, the Hindu body, and say the Catholic body, and now you speak for the entire community, but say, we recognize there are these different voices, and different people are going to engage differently. It's a question of mediating it. And I suppose this also speaks to Professor Toniati's question about democratic choice, because it does then become the question of how even democratic choice is expressed. Is it the individual at the ballot? Or is there something in the democratic process which says, yes, I'm an individual, but I'm not just an individual. Sometimes, I'm thinking about people like Alistair McIntyre, Charles Taylor, and even Etizioni, that have said, we live kind of channeling Aristotle. If Aristotle said we are political animals, we are social animals, they're saying, no, we live also in groups, in communities. That's part of who we are. So what is the democratic legitimacy? How do we measure democratic choice? And then finally to Professor Marati's questions earlier about the limits of pluralism in the legal question, and then to the tolerability of specific cultural norms as a political question. Well, my answer to both of these questions is really that perhaps what we need to do is not look for an answer for all times and all places, but rather be contextual in our answers. And this also relates to the point you made about Singapore and India. Yes, one is like a small speedboat, the other is like this major ocean liner, we have to turn it around. Numbers certainly makes a difference, geography makes a difference, history makes a difference. I think the challenge in many societies, and I can see it now even in the ones where I'm living or the ones that I'm familiar with, is that the pace of change is so rapid, and the challenge to the old orders is so much that actually at best I think we should come up with tentative moments and always be willing to revisit them. And that may be where the constitutional lawyers here will have to be a little bit less sacred about the Constitution, right? And say, look, the Constitution says this, but that's not all that we can always be, and maybe we revisit this from time to time. So those are my thank you.
Thank you. Well, thank you very much. At this time, I think my task is to express the gratitude of the group to our panelists this morning, to the panelists yesterday, again to Roberto and Davide for convening us. Before giving the floor precisely to Roberto, I suppose, for his final remarks.
Well, that's very kind of you, Marco, to let me have the floor at this stage, mainly to say a few thanks and some farewell, I suppose. Now, the thanks go to a number of persons. Of course, all the speakers and discussants who really did an excellent job. And let me also give a special thanks and a word of appreciation to so many students, mostly from the course of Introduction to Asian Law, which Arif and I share. And I think that after having had perhaps 12 or 14 hours of course, they had this sort of full immersion into pluralism in Asian law. And I'm sorry we have to stop. I know you would like to have also another afternoon of discussion and perhaps the whole weekend, but we just cannot afford it. And then, of course, I would like to thank the administrative staff, Giorgia Sartori and Martina Franceschi, and also our technical support, shall we say so, who is also a student, by the way. So it's almost always within the house. Now, the very last words of our presentation, written by Davide and myself, is that the International Workshop has the purpose of contributing to a better understanding of the political and systemic dynamics of Asian constitutionalism and law, as well as the potential for expansion of the rationale of legal pluralism in culturally plural contexts. Now, from this point of view, I do think that this workshop has contributed to a better understanding, and I think this is really an asset that we can receive now. And as you know, you can permanently look at the seminar on the digital archive of the law faculty in Trento, so every time you have a doubt, you can go and check what or any of us have said already. Now, the very last word is this. We experience plurality in the world, and plurality is normally regarded as an indication of wealth of the human condition. Of course, plurality also has its negative part, or the bad part, as was said yesterday. But plurality is plural in its distribution in the world. And of course, history is also very important. Now, I always like to remember the fact that in the 1864 Constitution of Argentina, one of the spelled out purposes of the functions of Congress, of Parliament, was the conversion of the indigenous population into Roman Catholicism. And now the Constitution of Argentina acknowledges the applicability of indigenous law to indigenous populations. So forget about conversion, just the other way around. So the world is very rich, and history, of course, changes very much. Now the point is, and here I take the lesson given by Arif Jamal, this is plurality. Shall we switch into pluralism? Of course, this again reproduces the differences in the plurality in the world, the plurality of the context. We know that unlimited pluralism has negative effects, but we acknowledge that pluralism has pitfalls but also has potentials. So the big problem is how to manage the switch from plurality to pluralism. And as Nico said earlier, this is a global problem. It's not a problem belonging to the north or to the south, but it is a global problem. Of course, the improving our knowledge of pluralism where it exists is an excellent and I would say a necessary instrument in order to be able to try to think that we may somehow ultimately manage pluralism, and that's very interesting. We had micro comparison, we had macro comparison, we compared Asia and Europe, we mentioned Latin America, occasionally North America, we also did a little bit of Africa. So I think that we have taken care of the problems of the world, and we may be satisfied from this point of view. So thanks to all, and I hope to see you back to Trento in a short time for another good international workshop. Thank you very much.